Hi everyone, welcome back to the Learn, Invest, Grow show. Joining us today is our special guest, Barry Bruce, venerable tax strategist. He's been providing income and estate tax advice for almost 4 decades. Apparently, he found his lifelong passion for tax even before Adam and I were born. Kudos to you, Barry, and thank you for being with us today.
That's what venerable means, right? Just some old
Yeah.
guy.
No. There's a lot of respect for you. We have a high regard for your career and passion for tax.
Yeah, and thank you. Thank you, Barry. One of our investors, he speaks highly of you. He's like, oh, you gotta talk to Barry. He helped me set up my trust and protecting my wealth for myself and my family, so that just means a lot, and we're just so happy to have you on here. Thank you, and
happy to be here, of course.
Okay, so today we're going to discuss two things at large. The first one is why it's critical to keep asset protection in mind when building your wealth, and the second one is how the new tax proposal may have an impact on retirement accounts such as a self-directed IRA. Okay, let's get to it. So Barry, when it comes to formulating tax strategies, you're a big advocate of asset protection. So can you tell us your definition of asset protection and why it's such an important consideration for wealth building?
Sure. I think I'll answer the second part first. I tell people all the time that our first rule of tax planning is to protect your assets, because all the tax planning in the world doesn't do you any good if somebody slips and falls in a property that you own, or you bump into the wrong person at a traffic stop and somebody else ends up with your assets, right? So first rule of tax planning is don't lose your assets, right? And then as to what asset protection is, it's a good question, because I think the misconception is that asset protection keeps people from getting sued. The reality is you can put up a building that blocks somebody's view of the horizon, or paint your fence the wrong color that offends their sensibilities, and they'll sue you, right? You can't stop people from suing you. Asset protection is not about whether or not you can get sued. Asset protection is about control over the consequences of getting sued, even control over the circumstances if you lose a lawsuit. If your creditor ends up with a judgment or with a charging order, are you at their mercy, or do you have at least as many cards in that hand as they do? And real asset protection is a conscious strategy, a conscious set of actions that are intended to make sure that not only do you have as many cards as your creditor does, but very often you have more cards than they do. The objective is, if a client of mine loses a lawsuit and the creditor ends up with a judgment or a charging order, I want my client to be in charge of if, when, and for how much that lawsuit ever gets settled, even if the creditor has a judgment and a charging order. That is asset protection. If I can tell my client, somebody who knocks on your door with papers to deliver to you, if you can answer their knock by saying, I'll take your papers, you just need to understand that I own my assets in such a way that the state in which we both live, or we do business or whatever, has specific statutes in its code that provide that the courts in this state will not force me to turn assets over or distributions from the business that the entity within which my business operates. And you can knock on my door every other Sunday if you want to. You can come late at night and early in the morning if you want to. If you want to be reasonable about this, then maybe we can talk. If you're going to be unreasonable about it, then I've got cards that you don't have. That's asset protection.
Very interesting. And I guess like one thing people feel like, you know, they're protected because, oh, I own it under an LLC. It's a limited liability company, right?
Sure. Yep.
So that's I guess a fallacy. And what you're touching on is something that's really protecting you and your family, so they can't pierce the corporate veil.
I think the point that you're getting at is that maybe as the decades have gone by, we've gotten used to an explanation and an understanding of what state codes have to say about asset protection that's provided by LLCs and corporations, right? The truth of the matter is, like so many things, if you dig into the matter behind what's written in a newspaper article, even if it's the Wall Street Journal, or in a Forbes article or anything where someone who has a basic understanding of an issue is just sincerely trying to communicate some information. If they don't have the perspective of somebody who lives in that space and deals with those fights every day, what they might unconsciously be doing, unwittingly doing, is passing along a perception, but not a reality, okay? If you have a public company, then the laws of the 50 states that govern the way that corporations and LLCs organized in those states function will absolutely provide you with bulletproof asset protection if you own a public company. If you own, in fact, a company, an LLC or a corporation that has at least 35 owners, whether they're individuals, partners, other entities, whatever. If your entity, your business is owned by 35 or more owners, you'll have bulletproof asset protection under the laws of the state that you do business in or live in that govern LLCs and corporations. The problem is that most of us don't own our assets with 34 other people. Probably most of your clients are not investing the funds of a public company, all right? So the theory about what state law provides in the way of asset protection genuinely applies to those bigger entities, but isn't applicable at all to the entities back here in the real world where you guys, me, most of our clients live, okay? And in those instances, what's called a close entity, C-L-O-S-E, whether it's a close corporation or a close limited liability company, a close organization is deemed by the laws of most states to refer to an entity that has fewer than 35 owners, okay? And if you can grasp one thing about how all this works in reality, it's this. The question about liability boils down ultimately to a matter of control, right? And let's go to the extreme. Let's say that the two of you own an LLC, okay? And at the end of the month, your LLC's got $1,000 left in the bank that it doesn't need for next month's operations, right? And you say, tell you what, let's have a picnic, okay? I'm making up a crazy example, but just to prove the point, right? Let's have a picnic, all right? You don't have to go to a board of directors to get permission to have the picnic. You look at one another and you say, do you think it's a good idea? And you say, yeah, let's have a picnic. and the decision is made to spend the money that easily because the two of you can exercise that degree of control over what happens with the corporation's or the LLC's assets, okay? Contrast that with, say, Tim Cook at Apple Computers, CEO of Apple Computers, right? If Apple's got $1 billion in the bank at the end of this month that they don't need for future operations, and they decide, Tim Cook says, we should buy an island, and create an entertainment mecca for our best customers. Tim Cook can't make that decision on his own. He's got a board of directors that he has to answer to, okay? And that difference between literally looking at the decision maker in the mirror versus the inability to look at the decision maker in the mirror, that's ultimately where plaintiffs' lawyers, in other words, the lawyers for the people that you lose become your creditors, right? They use the control that the two of you or a couple of people from a family, right? Or a couple of buddies that went to school together, or some plumbers that met one another at a barbecue one day and decided to go into business together. And they say, wait a minute, you really operate from day to day as if the stuff inside that entity was your stuff. It's called alter ego, A-L-T-E-R, ego, E-G-O, right? And if you are basically treating the assets of the entity as if they were your assets, control-wise, then my client, if I'm the plaintiff's lawyer, should have the right, Your Honor, to go after any assets at that person's disposal, whether those assets are owned personally or those assets are owned inside an entity. And that really is how the issue works in the long run. So in a real world example, right, you stop on the way home today and get some gas, all right, for your car. You have a personal debit card and you have a debit card that's got the name of the business on it. And you're in a conversation, you're probably on the phone, and you reach in your wallet and you grab one of the cards and you put it in, and it happens to be the business card, okay? You were talking to your wife about where you guys are going for dinner tonight, right? You weren't doing business, but you used company assets for a personal purpose. And that quote unquote commingling of assets for these smaller entities where we all live in the real world, that is one of the doorways through which a plaintiff's attorney can walk to say, Your Honor, disregard that entity because Adam and Tay are really using the assets of that entity as if they were their personal assets. That's a conceptual understanding. And then if you go to the specific codes of each of the 50 states and DC and look at their state codes, then what we just described in generic terms, they put into legalese and enact into law, right? And you end up with situations where, for example, you expect, I guess, sorry, but you expect things to be a little different in California, right? And there's a very important case that was decided in California. 4 guys owned an LLC. It was a California limited liability company. They were in the commercial real estate business, and they had a piece of property that they wanted to sell and hired CBRE, huge commercial real estate organization, to sell that property for them. A couple of months into the deal, they weren't real happy with the way that it was going, and they terminated the agreement with CBRE, hired another broker, and the other broker successfully sold the property. The sale proceeds were distributed to the 4 guys that were members of that LLC, and then they dissolved the LLC. They filed the articles of dissolution with the Secretary of State's office, Franchise Tax Board in California. So the LLC no longer legally exists. And then within the statute of limitations, CBRE sues them for the commissions that it believed it had the right under its 1-year contract, which these guys terminated early, right, to those commissions. And in the end, the appeals court in California backed CBRE and allowed CBRE to exercise a judgment against the 4 individuals who were no longer even in business together in a business that didn't even exist. Okay? That's LLC stuff. And the reason that the courts permitted all of that is because of this concept of alter ego, right? Or in other situations, commingling of funds between your personal pocket and your business pockets and all of that. There's a couple of other instances in Nevada where people normally think the rules are awesome, which they are in most cases. But even in Nevada, there was a case where a couple of guys owned a water park, and they were made aware that there was some kind of issue mechanically with one of the protective devices. I think it had something to do with the rapid dispensation of water jets and stuff like that. But these guys were aware of it. The water park was owned by an LLC, and an accident happened. Some people got hurt. Those people came after the owners of the LLC itself. And even in Nevada, the Code of Nevada says that your personal knowledge of a potential for an injury is not sufficient, is reason enough for the court to say that the LLC that owns this asset is not intended to protect you against that personal liability. You guys knew there was an issue individually. We have a record that shows that employees told you about it. You didn't do anything about it, and we're allowing the people who got injured to sue you personally, not just the entity, but to sue you personally, right? So that's all of that, I guess, in the long run, is more, as I said in the beginning, it's not that lawyers who create LLCs and corporations for you, or accountants that recommend them to you, or writers for journals that, none of them are intentionally trying to steer you in the wrong direction. It's just that after years and years and years of writing down, oh, you're going into business, you're going to buy some rental properties. First, get yourself an LLC, right? And just the last thing I'll say about this at this point is everything that we've talked about corporations and LLCs kind of sits at this level. If your LLC is one that you alone own, or you and your wife own together, what's called a single member LLC, then in every state in the United States except Wyoming, the presumption is that that entity does not exist for liability purposes. Wyoming is the only state in the country that provides the same measure of asset protection for single member LLCs that it does for multi-member LLCs and corporations. And you don't have to live in Wyoming to have a Wyoming LLC. You can live wherever and have a Wyoming LLC. It's just that most LLCs and corporations in the United States aren't created in Wyoming. They're created where the people live. If you live in California, you're probably going to have a California LLC. If you're the only member of that California LLC, you don't have any more asset protection than if you didn't have that entity and if you weren't sending $800 a year to the franchise tax.
This is incredible.
Sorry if I put you guys to sleep.
No, I'm
No.
listening. I'm listening attentively, and this is a wealth of knowledge that I did not know about. and it gets very complex. There's a lot of things, and this is why we brought you on, Barry, is because, we deal with a lot of investors and or business owners that are they're misguided, thinking that they're protected and their families are protected because everything is owned under an LLC, and that's really a fallacy. And they need people like you to give them the proper guidance on how to really protect themselves and their family.
So here's the simplest statistic that you can offer those people, right? And they can verify it in public records in their own state. But across the country, in some states, the ratio is worse. In some states, it's a little bit better. But across the country, in about 40% of all federal court cases that involve an LLC or a corporation in a liability suit, and in about the same percentage of the cases brought in state courts, the plaintiff's lawyer, the lawyer for your would-be creditor, if they're successful, is able to pierce that wall that's supposed to separate business assets from personal assets in about 40%, a little more than 40% of the instances. That's almost 50-50, which means that the asset protection that you're getting from those entities, unless you have 34 partners or a public company, right? The asset protection that you're getting is basically a coin flip.
Wow.
Right? And it's not a malicious kind of thing. I don't believe that any attorney that ever recommended one, that you get an LLC or an S corporation or anything like that, I don't believe that any of them, any CPA, no business writer, I don't believe any of those people have done anything intentionally to leave you at risk. It's just that unless you literally look at the record of the court cases and see what happens when people literally end up in court, you wouldn't know that it's a very incomplete asset protection unless you own your organization as one of those that the protection is sufficient for. 35 or more partners, publicly owned.
That's really, staggering statistics. So, I mean,
Yes,
basically the business law recognize the notion of an alter ego in that it will impose a liability on the owners of a corporation or LLC that do not separate themselves from their business. So basically,
Correct.
it's very easy to get the corporate veil to be pierced in this sense, right?
Right.
Then the question is like, what could be a better tool
Can I
than
just say one thing
LLCs
quickly?
and corporation? Yes,
Can I say one thing quickly before you answer the question? Because I've had this come up in conversations with people before. You use the word corporate veil, right?
Yeah.
And I've had people, especially in the last 25 years, since every state at this point in time, all 50 states have their own limited liability acts at this point. It's like, well, I don't have a corporation to have a veil. I have an LLC, right? If you go to the California code, for example, it's just an example. It is extremely explicit that the personal liability that extends to the owners of corporations who cross that alter ego or commingling of funds line, right, is shared identically with the owners of limited liability companies. If you literally look at their Limited Liability Company Act in California, the thing that created them in California, it's explicit that there's no difference between the so-called corporate veil and the so-called LLC veil, except that there's no way to finagle LLC into something that ends with ATE, to make it an LLC-8 veil. You with me? So it's equally applicable whether they're corporations or LLCs. Okay, sorry.
Yeah, thanks for a clarification. I think that's important concept to highlight. Yeah, so back to my question. We're obviously like a LLC and a corporation have its own limitation, unlike our common preconception about their asset protection adequacy. Then what could be the really alternative, a better tool than LLC and corporation can provide? Like a real bulletproof answer to asset protection concern.
So you have to change the playing field, right? Sun Tzu said, in effect, he didn't probably use these words exactly, but his concept was, if you're in a fight and it's not going your way, fighting harder isn't always the solution. Sometimes you have to move the battlefield, right, to a battlefield that's more conducive to your capacity to defend and fight, okay? And in this instance, the way you move the battlefield is you move away from statutes, state statutes that define how you operate as a corporation or an LLC within that state to contract law, okay? There are two kinds of trusts. There's an infinite number of kinds of trusts. I shouldn't have said two, but there's two broad categories of trusts. One is called statutory trust. Most of your investors are probably familiar with Delaware statutory trusts, right? Most people believe that a Delaware statutory trust is synonymous with one way to rescue a failing 1031 exchange, right? Oh, I'll get a Delaware statutory trust investment. Well, a Delaware statutory trust is a trust. Some people own real estate in them, right? Some people operate businesses in them. Some people take care of their families within them. The Delaware Statutory Trust is a trust that was established by an act of the Delaware legislature that created a kind of entity, right? Some people have chosen to use the Delaware Statutory Trust form of ownership to purchase real estate and provide fractional interests in that for investors who need to complete 1031 exchanges and are having trouble finding individual properties to buy, okay? But that Delaware statutory trust is a trust format that was literally created by an act of the Delaware legislature, and it's got certain rules you have to abide by if you're going to use it. You have to have a Delaware resident as one of the trustees of the trust, for example, okay? Those are statutory trusts. The other kind of trust is what's called a common law trust. Common law trusts are derived from Old English and European common law, right? That basically says that unless you are inhibited by an act of the court, in other words, you committed a felony, for example, free adults have a free right to enter into contracts, okay? And if, for example, someone creates a trust, Tei creates a trust and gets together with Adam to be the trustee of that trust to take care of Tei's parents, okay? That document that has the appearance of being a trust instrument, maybe even look like a will in some cases, but technically it is a contract entered into between Tei and Adam where somebody is taking some property and putting it into a trust and turning to someone else and saying, I want you to manage these assets. I want you to have the legal authority to control these assets for the benefit of this group of people. In this case, it happens to be Tei's parents, because in our example, they don't have the experience themselves to manage those assets. Tei's worried about somebody taking advantage of it, okay? That relationship between the person who creates the trust, Tei, who's called a grantor, G-R-A-N-T-O-R, or a settlor, S-E-T-T-L-O-R. There's other names, but they're all interchangeable. The person who creates that trust, called a grantor, and the initial trustee, in this case, Adam, enter into agreements with one another, right? I'm going to put this property into the trust. I want you to do this with the income. If one of the beneficiaries gets in trouble and they don't have enough income, I want you to go into the principal of the trust and take money out of the principal of the trust and take care of their needs. Or you could say, as the person creating the trust, don't you touch the principal of that trust. I don't care if they're not eating that week. You leave the principal of that trust alone. Those are the terms of the contract between those two parties, okay? And if the terms of that contract state that the trustee is prohibited from distributing any income to any person who's not a beneficiary of that trust, or invading the principal of that trust for the benefit of any person who's not a beneficiary, then those are the terms of the contract. If you go to the California Probate Code, if you go to the Florida state statutes, just two examples, there are explicit boundaries provided for in those state codes that say the courts in our state are prohibited from forcing the trustee of one of these specialized trusts from breaching the contract between the grantor and that trustee. Okay? In English, what that means is that somebody slips and falls in your rental property, or you're driving and you bump the car in front of you at a traffic light, right? If the car is owned, all right, or if the property that you own is owned by one of these common law trusts, and the terms of the trust are purposefully drafted to take advantage of these state codes, right? Then when your creditor, you drop the banana that somebody slipped on, right? There's no denying that you have some part to play in their injury. They slipped, they broke an arm, they missed a couple of weeks of work, right? There's no denying what happened, right? If that property is owned by one of these trusts that we're talking about, then if the terms of that trust say that the trustee is prohibited from distributing assets or income from that trust to a creditor of the beneficiary or a creditor of the trustee, then unless the person who slipped and fell is a beneficiary of that trust, the creditor can't force the execution of a judgment against that trust. They can't reach, that's the legal term, the assets that are in that trust, or they can't jump in front of a beneficiary and grab a distribution from that trust, okay? And that's what I said in the very beginning when I was talking about how real asset protection is about maintaining control of what happens even if you lose a lawsuit, okay? Look, if your conscience is bothering you because you know you dropped that banana and you want to settle with the person, who got hurt, then you have the means to do it within the language of the trust. You can still work with it. It's just that they can't force your hand to do it. They want, a couple $1 million from you because they broke an arm and they missed a couple of weeks of work. And you might say to them, look, I feel bad about what happened. I really do, 40 grand, to me, that seems like a lot for breaking an arm and missing a couple of weeks of work. But if you'd be willing to settle this situation for 40 grand, then, I'll work with you. I'll get it done. And the language in the trusts allows you to get that done. But if they're going to be obstinate and demand that because they got a judgment from the court that says you owe them $2 million, the jury decided in their favor, and you owe them $2 million, fork it over. They're out in the rain. They're out in the cold because the state law that's applicable to those kinds of scenarios supports you as a party to a contract that inhibits your ability to do what that person is demanding that you do. So you can literally look at them and say, you can come back here, every other Sunday if you want to. You can knock on my door, you can hand me some papers, and the answer is going to be the same. I don't have to pay you. The courts will not make me pay you. If you want to be reasonable and settle this, then I'm all ears. Let's talk. But if you're going to be ridiculous about it, just keep knocking on my door. That is asset protection.
And another thing,
and that is bulletproof, not a coin flip where 40 couple percent of the time it works in your favor and 50 couple percent of the time it works in your opponent's favor.
And what if someone's like, well, what about insurance? Does that protect you the same way or more? Or can you elaborate, explain a little bit
Sure.
about that?
So insurance is obviously an important tool in any kind of planning of this sort, right? But one thing that your clients need to be aware of is that in a lot of states across the country, punitive damages, which are mostly the larger part of a damage award, are not permitted to be insured. And a lot of people scratch their heads at that, but there is some logic to it. The root word of punitive damages is punishment, right? And for you to have done something that you shouldn't have done, right? Or if you'd been paying attention, you'd have done it differently or whatever. And for you to get rewarded by making the insurance company pay for your mistake, well, that's kind of, that's bad for the insurance company and not good for you, right? So the laws in a lot of the states, I think you guys are headquartered in New Jersey, New Jersey being one of them,
Correct.
prohibit punitive damages from being insured. So you might have the base damage, somebody slipped, they've got some medical bills, they lost wages, that part of everything is something that can be insured. But in a lot of states, the quote unquote slap in your face that says, don't ever do that again, you shouldn't have done what you did, and you shouldn't have done what you did, that part of the damages in a lot of states can't legally be insured in the first place. And even if it is insured, it's still a fight. If you're contesting what they're doing, right, there is no leverage like being able to hold up a statute, a law of the state in which you do business or live, that says there is a contract between me and this other person that is the framework within which this asset that you fell in is owned. And the terms of that contract are consistent with state law that says you cannot force me to reach into that box and take money out of it and give it to you. So can we just be reasonable about this? I'm not asking that people have the right to abuse other people and get away scot-free. That's not the point at all, right? The point is just to inject a device into that court process that provides leverage on the part of the person who is most often looked at as guilty and abusive because they have some assets in the first place. They're not guilty and abusive because they have some assets. Most of them have worked hard to create those assets. Why should they just be forced to turn those assets over to somebody else who thinks that the loss of a couple of weeks worth of work and a broken arm is worth $2 million of pain and suffering? With me? Change the battleground. Move the fight from a wide open space to an area where you're on top of the hill and your opponent is squeezed into the little valley between them, between the two hills, because they're much bigger than you are and you've got a much smaller army. You can't fight them in the open. But if you can narrow the battlefield and get above them, you can fight very effectively. That's all we're talking about, is change the location of the battlefield from one where you can't fight to win in more than half the cases to one where really the odds are very much in your favor of winning because you're using a different set of rules. Does that make sense?
Yeah, absolutely. Yeah, I mean, it's really a revelation that, yeah, the trust can be a viable asset protection tool. And I mean, we're gonna actually delve into many different trusts and how these trusts work in detail in our webinar, which we're gonna host at the end of this month. So yeah,
Cool.
please stay tuned, and
Yes.
you're gonna talk more about it.
Yeah, stay
So-
tuned, everyone. This is an exciting topic. I, for one thing, I'm learning a lot from Barry. I just feel humbled just to have you on here, and really looking forward to the webinar to really just help add value of misinformation and helping really just educate others on how to really protect themselves and their family.